This video is entitled How to Make Yourself Bulletproof, and it explains the things that an agent should do to keep themselves safe from problems and lawsuits. Real estate agents are frequently targets for lawsuits or TREC complaints because human nature being what it is, no one wants to accept responsibility for their actions. They want to blame someone else, and usually if an attorney is involved, uh, they will do what I call the scattergun effect, which would be, name everybody possible, the agent, the broker, the seller, whoever, to try and see who will blink first. Okay, so that's what usually happens in situations. Now, regardless of your knowledge or culpability in the situation, you have to defend your actions in any lawsuit or complaint. And you have to do so in a precise and professional manner. Now, broker will assist because they usually are dragged into any complaint, but it always is best to go through the broker because they have extensive experience with dealing with TREC legal situations. You don't want to do this by yourself. If you have any type of a complaint letter for either from TREC or an attorney, start with giving it to the broker, and then we'll work from there. Remember, many attorneys know that you have E&O insurance. So again, maintain good communications, keep your clients informed of all significant developments, and respond promptly. Uh, an excuse that, well, I was on vacation and I was with my family, I'm sorry, uh, that doesn't cut it. All right, that is not a valid excuse. When you accept the responsibility of representing a client, all right, you're putting their needs and wants ahead of your own. All right, so I hate to say it, but family comes second and the client comes first in many situations, especially if there's a detrimental effect from you not paying attention to what is going on in the transaction. Right? One of the things that you want to determine if there is a language difficulty. If you have a hard time understanding somebody and English is not their second language, don't proceed without getting someone else involved um, in the process, because inevitably what will happen is they'll come back to you and say, well, I didn't understand, it wasn't clear to me, and you can have a hard time explaining to any kind of a complaint person that well, yeah, there is a language difficulty, but I thought they understood. Have somebody involved who speaks their language and is crystal clear to them on what's going on. Okay. Avoid giving false expectations to a client. So we see that with listings sometimes. You set an unreasonable price without counsel. In other words, when you suggest, and it's a suggestion of a price for a seller, what you want to do is substantiate that with enough documentation that makes sense. If there's an argument involved or they are unreasonable about setting the price too high, you need to counsel them as to what the potential results will be from overpricing the house, and maybe also suggest that they get an appraisal to verify what the house is valued at. Okay? Don't sugarcoat bad news, such as showing issues. If you know that the house is a pigsty, tell your client the house is a pigsty. That's why we're not getting any offers. People are turned off by whatever, whatever they have there. The 6 cats running around, etc. Right? Um, Never give a false impression to or an expectation to a client, such as, oh, this house will sell real fast. No. You're supposed to be objective in these type of situations. Okay, you should never make a decision on behalf of your client. If they come to you and say, well, what do you think? What do you think is a good question, because they're asking you for advice. But you should not make the decision. It is their decision based on the information provided to them. Now, what's the difference between advice and opinion? Well, everyone has good intentions. There's a huge difference between someone that is qualified to give advice because of their experience and background read real estate agent, versus the person that has limited or no experience and is unqualified to give advice. Hence, it's just an opinion. Now, we've seen that where they're talking to their neighbor next door. They're talking to their brother-in-law. Oh, you have the house priced too low, or you know that house this, that house that. It'll sell real fast. So you have to kind of weed your way through the storm of other people giving them opinions, okay, where you're giving them qualified advice, okay? Provide a complete and accurate assessment of risks, but have the client make the decision as having an inspection done on the property. You tell them the pros and cons, and if they elect not to, then you have them sign that form that says, I elect not to have an inspection. Educate your client by giving them some of the forms that are available. TAR 1506, general information and notice to buyers and sellers. A wealth of information. You should always get in the habit of using that on every deal, every transaction. There's another one that's hardly ever used, but it's a good one, 2504, Texas Real Estate Notice Concerning Hazards and Deficiencies. What it does, it explains to people the difference between what an inspector is going to find and what might be grandfathered in from a property. So it's good information because we know what happens in an inspection. Inspector goes out and he says, oh, you need GFCI switches because they're near a water source. Well, that's correct according to current code, but they don't have to be changed if the house is pre-code where it wasn't required. This explains those situations, all right? So whether you represent the buyer or the seller, get in the habit of using TAR 1925 buyer's walkthrough and acceptance form. Make the buyer walk through, you know, before closing, say, okay, I've walked through, I accept the property. It'll avoid problems later on. You don't want to deal with these things post-closing. Document any advice that you give your client and the client's decision, okay, via email and confirmation of any instructions that you give them. And of course, do not allow yourself to follow any instruction of a client that is illegal, unethical, or dishonest. I would caution you to avoid filing fee disputes against your client. It eats up time and resources and a distraction and could wind up in a countersuit. Now, that being said, all right, if you're talking about a significant amount of money, if you're selling $1 million home, and you have a buyer's rep agreement, and the buyer goes rogue, and all of a sudden you find out that he bought $1 million home with somebody else, that's worthwhile going for, okay? But you have to use that discretionary, okay? You have to be very thoughtful about how you proceed in that regard, all right? Avoid the extremely difficult client who makes unreasonable demands, who constantly questions your advice or opinions, who exhibits angry or irrational behavior. And we've all seen these people. Our husband and wife who are having conflicts or are divorcing. We just had an agent in our office who finally gave up. She couldn't handle anymore. And I was in touch with her frequently. The husband and wife are getting divorced, and it was a complete catfight. They couldn't agree on anything. So finally, she said, "Look, we're getting nowhere on this. Everything is, one side is black, one side is white," and she finally gave up and gave up the listing. She said, "I'm terminating the listing," and walked away. And I think it was a good choice because the emotional roller coaster, all right, and aggravation and stress that she suffered wasn't worth it. There are other clients out there that you can spend quality time with. So don't be afraid to walk away or fire your client. Avoid, of course, unethical, discriminatory client. Unethical clients can expose you to not only a grievance proceeding or a civil action, but could also expose you to criminal actions as well. Deceptive Trade Practices Act, for example. All right, if you get involved in concealing something in, say, a seller's disclosure, all right, you're setting yourself for a serious problem. All right, and of course, discriminatory clients, you have to understand fair housing rules, and you don't get caught up in a client that is biased or discriminatory. Do not favor your interest over your client's interests. All right, and here's where uh, the potential danger of intermediary, where husband and wife are representing both sides of a transaction. You got to be very careful about that. If I had my way, I would say, a husband and wife could not represent both parties, but that's not illegal. It's just extremely dangerous when you do that. Uh, you know, the impression of a husband and wife not discussing the transaction is ludicrous. Um, so just be very careful if you're in that situation that you are objective and you're representing the interests of your client above all else. Be proactive in addressing client complaints. Be responsive and provide info and a plan to resolve. If you need help, you talk to your broker. All right. Another way of preventing problems is educate yourself. Learn, learn, learn. Unfortunately, most agents just do the bare minimum. They take what is, necessary to renew their license, and they go no further beyond that. And I think that is foolish. Uh, I would suggest you take more CE courses than needed. Uh, get a designation that benefits you. GRI, Graduate Realtor Institute, good one. Good all-around designation. ABR, Accredited Buyer Representative, and CRS, Certified Residential Specialist. All good designations. There are other ones, of course, that are more focused on a particular segment, seniors, commercial, property management, etc. So look into those, educate yourself, and continue to gain more knowledge. All right. Here's ways that you can do that. Periodically read the frequently asked questions on the TAR website, texasrealtors.com, and the TREC website. Okay. Uh, that has a wealth of information, just browsing through some of the questions that are asked and seeing what the answers are from a legal standpoint. All right, subscribe to the TAR magazine online or paper. All right, that gives you all the latest tips every month, I believe. Attend free courses held by vendors at title companies and other folks. The lenders are always, giving out seminars, CE credits for a minimal amount of money, $5, $10. Attend those. It's worthwhile, and you'll learn something. And by all means, subscribe to Allegiance Title's Tip of the Week videos held by their attorney. Just go to allegiancetitle.com and you'll see Wendy Way in there, and you can subscribe to getting her Tip of the Week, which is Dawn Moore, the attorney. Don't feel embarrassed to call TAR Legal Hotline or your broker if you have questions. All right, proficiency. Don't jump into a facet of real estate that you know nothing about until you educate yourself. In other words, property management or commercial. You owe your client proficiency and professionalism, not on-the-job training. Okay? So if somebody comes to you and they say, well, I want to buy a commercial property and I need this type of cap rate, da 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 da, and you don't know what the heck they're talking about, don't get involved. All right? Get somebody involved with you, all right, that knows the buzzwords, knows what's going on, and knows that facet of real estate. All right. Property management has a lot of pitfalls if you don't know what you're doing, and the same thing with commercial. So the last thing you want to do is look like a complete idiot. So don't get into areas where you're not knowledgeable. Request assistance from an experienced agent to help you through the deal and offer either a referral or assistance fee. Right? Pay attention to all documents. Become familiar with all the real estate forms available on zip forms. Read everything carefully and thoroughly for dates, time to do, etc. I am continuously amazed at what I see submitted for compliance review that has no dates, all right, like contract execution date, has no dates on the seller's disclosure, isn't signed, isn't initialed. I mean, an agent should be reviewing these things before submitting them. So read everything carefully and thoroughly and make sure that it's complete. Explain to your client in detail what they are signing. Don't just put a piece of paper in front of them and say, here, you need to sign this. Okay? Explain what it is. Create yourself an alert system to let you know when the option period is ending, when credit approval is ending. In other words, protect your client. They expect you to do that, right? So a little tickler system that says, hey, guess what? You have 2 days left to get full credit approval. So, you know, make sure that that's done. Otherwise, we may have to pull the plug on the contract if you can't do that. All right. Some of the reasons for becoming a target, well, failing to disclose a property defect. When a client sues an agent for failing to disclose a property defect, they have to prove the agent knew or should have known about the defect and failed to disclose it. Now, you say, well, why would they sue an agent? Well, you represent a seller, all right? And there's a glaring defect that the seller failed to disclose, either knowingly or unknowingly. Now, who are they going to point the finger at? Well, they're going to point the finger at the seller, of course, but they're also going to point the finger at you as the agent because they feel that you have the expertise and you should have known that there was a defect. So you're going to get pulled into it one way or another. So make sure that when you do a seller's disclosure from a seller standpoint, then you want to make sure that it's accurate, okay, and it represents the property. Don't be ashamed to ask them as many questions as necessary. Breach of duty. Real estate agents must always act in the best interest of the client, as clients place a trust in real estate agents for their expertise. All right. So those are some of the reasons for becoming a target when you fail to disclose a property defect or a breach of duty by not doing what you're supposed to do. Representing clients in unfamiliar territory. Well, we talked about that. Do your research, ask someone experienced for help, and you won't know all that is required. So if you're getting into a gray area that you know nothing about, seek help. All right, and it could be a very simple thing. It could be somebody's doing farm ranch contract. If you've never done a farm ranch contract, there's things you need to know. You know, what conveys, what doesn't convey. So ask for help. Don't jump into something that you don't know anything about. Giving legal advice. Well, that's been beaten into everybody's head over and over. Don't give legal advice. And legal advice is not only legal, but also tax advice. Some clients expect you to have all the answers, and human nature being what it is, agents don't want to appear unknowledgeable. So this applies to tax issues and legal real estate issues. Misleading clients, don't exaggerate or embellish. Don't leave room for misinterpretation. Be crystal clear. Breach of contract. If a client breaches a contract, usually for failing to comply with time frames in the contract, it is often accompanied with claims of negligence or breach of duty on behalf of their agent. Okay, so if you know that there's a potential breach for your client, make sure they're aware of it before it happens. Okay. Again, it goes back to having that time frame tickler file. Failing to keep your client's data safe and confidential, not a catastrophic issue, but don't keep info such as lease applications or mortgage applications visible. All right, put them in an archive folder somewhere in dotloop that it's not available to the public. Failure to recommend inspections by qualified inspectors, etc. All right, what you want to do is use TAR 2506, which lets you recommend a number of inspectors, and you should always give them at least 3 choices, so it doesn't look like you're steering them towards one inspector. And then what you want to do is have them choose one of those, or check the box that says, I elect not to have an inspection, right? Good habit to get into using that form. Negligence. Client can claim that an agent should have known something but did not and failed to take appropriate action. That's a very clear definition of negligence. That you should have told them, but you failed to do so. All right, you were negligent in in supporting your client. Now, negligence differs from fraud. Negligence lacks intent. Fraud is intentional. So, bottom line, a lot to discuss, a lot to chew on. Don't be unprepared. Look at this guy.